call. Yeah. I just got to the study room and it's 2:45. Got here about 5 minutes ago. Just loading some emails. I sent about 2,500 emails today. Yeah. And there seems to be this issue in prosecuting attorneys' offices, as if an individual would take personally the issuance of a court order without being given due process. Yeah. And I was just reading Mr. Roberts' statement, Brett Roberts, about, well, it looks like the he's angry about this. Oh, conclusion, Mr. Budnick's own correspondence on the date, which he is alleged to have violated the no contact order, reflects that he was aware of the order and angry about the fact that it was issued. The state need not prove personal service of the order, rather it need only prove that Mr. Budnick had knowledge of the order's existence. Evidence available to the state establishes a prima facie case. It's obvious that Mr. Budnick had knowledge of the order and knowingly violated its restraint provisions on the date for which he is charged with the crime. Oh, the prima facie case that Mr. Budnick obviously did know of the order's existence and that you don't have to prove that it's a valid protection order. You just have to prove that the court issued it. Now, when I was looking through this, yes, since 2011, Mr. Roberts, yes, Mr. Budnick has not been given notice and opportunity to be heard. Now, I don't know the personal lives of those that are prosecuting attorneys, but if the protection order had been issued with the requirements of the law being enforced, I probably wouldn't be angry about it because I would have gotten notice of court hearings. Yes. And this concept of issuing court orders without any notice or opportunity to be heard, will you take somebody's kids? And then you say, well, we're sorry. You got a little problem, don't you? Well, Mr. Cowgill and Mr. Roberts both seem to think that just because a court issues an order that it's valid. Oh. Now, the prosecuting attorney's state's response, right, that I am involuntarily going to be administered antipsychotic medication so that I won't be angry. Is that right? Doesn't that what psychotic means? That I'm angry that you issued a court order where you did not give me actual notice? Yes. Well, you arrested me for the 2-count criminal complaint, and you say, well, he knows about it if he has a problem. It looks to me like prosecuting attorneys don't really believe that there's any process for the conviction of a crime. It's almost as if, well, we know it's against the law that they issued it, but big fucking deal, they can do whatever they want. Now, this is Exhibit B. Oh, you issued it, yes. You arrested me, yes. You reissued it, yes. I was found not guilty. Oh. You reissued it? No. You modified it? Oh, you reissued it? Without any due process. You issued it without the signature. You issued it with or without a forgery. With the duress that I had a weapon or without. Oh. Then you arrested me. Oh, for a traffic citation. Yes. And then you don't seem to understand that there was no actual concise statement of what the fucking crime is. Now, it's not psychotic to be angry when your civil rights are not being enforced. Mr. Cowgill had the same flippant fucking idea that, well, the defendant has had significant time to seek a remedy in regards to the order for protection. Section 9 of the order specifically allows the defendant to seek review of the order as if it was something nice of the court. You're going to allow me to motion the court? Do you know I can motion that fucking court every fucking day of the week? I don't need you to tell me that I'm allowed to motion any court. Now, the prosecuting attorney's office treats citizens and civilians as if they're second-class citizens. Well, we're the prosecutor. You'll do whatever the fuck we say. Pooh. But as Mr. Calgia was a total fucking dick. Not only was I found not guilty during the first trial, yes, he was the prosecuting attorney during that. There's a conflict of interest that he might have personal motive in wanting me admitted to Western State Hospital. And Mr. Roberts, this whole concept of being angry that my sons were taken 7 years ago when I wasn't a resident of the state of Washington. Um, I am the deputy prop assigned to above caption matter familiar. Among the evidence available to the state. Well, when does the accused get the evidence from the state? When do you have to give the evidence? On Friday, June 16, 2017, to numerous recipients, including people at Heidi Budnick's workplace. I didn't email anybody at Heidi Budnick's workplace, demanding that someone remove the protection order that is at issue in the case. Did Mr. Roberts get a copy of today's email where I put some pictures in there and some videos? Among the many attachments associated with Mr. Budnick's demand to have the protection order is a screenshot of the protection order itself. Does do you declare under the penalty of perjury that that is a valid protection order, or are you just because Mr. Roberts and Mr. Calgill and every fucking prosecuting attorney in this nation, just because you issue a court order does not mean that the requirements of the law were enforced before you did it.